Okay. Welcome to the newest episode of Things Resolution or Think Resolutions. In this episode, I'm going to be interviewing Vilendrer. Did I pronounce that correctly? I didn't mess it up. I try to write it down. And Ellie is a mediator based out of San Diego. She
Irvine.
is a,
I'm out of Irvine.
oh, gosh, won't ask. I thought you were out of San Diego. Okay. Another mistake we made. And she's one of the preeminent leaders of the dispute resolution section of the American Bar Association. Our discussion today will be we will be talking about the host legislation that Ella has, I believe, co-authored or written herself
I've written it.
in California, having to do with mediation, and I'll let her describe that. And also, since this recording is about 2 weeks after the dispute resolution of the American Bar Association, I asked Ellie to two or three of her top takeaways. The comment, fortunately, I wasn't able to take this. My name is Howard Kline, mediator and arbitrator, currently based out of Las Vegas, but I've been licensed to practice law in California since 1970s. Was that before you?
That was before I was born.
I don't do that. I was trying to joke about it. As I said, my mediation arbitration practice is currently based in Las Vegas, and I'm the national panel members for the American Arbitration Association. So, without further ado, Ellie, take it away. Let's talk about your proposed legislation.
Thank you so much, Howard, for inviting me. First of all, it was a pleasure to get to spend some time with you and talk about SB 1141. A little background, I'm currently vice chair of the Orange County Bar Association's Legislative Resolutions Committee. I joined this committee last year and I proposed a resolution which would amend CCP 1775.5. It's California legislation, which currently allows courts to refer cases to mediation up to $50,000 in controversy. So this amendment would take that amount in controversy up to 150,000. And there's many reasons I did it. We can talk about that. But number one, it's over 30 years old and it hasn't even been adjusted for inflation in the over 30 years that since it's been enacted. So I'll go into that more, but just briefly on what happened between then and now is I proposed it, our committee approved it. It then went on to the Orange County Bar Association's board of directors who approved it. So then it was submitted to the Conference of California Bar Associations and it was unanimously approved there. So this process started well over a year ago. After I got the approval, then I had to look for a senator to back it. And I found Senator Niello up in Sacramento. And he's been amazing to work with. Him and his staff have been amazing to work with. And next week, now I will be testifying at the Senate Judiciary Committee hearing in support of this bill. And very pleased to announce that we've gotten a lot of support on it. We have several letters that have been submitted in support by different organizations, including, first of all, we have a letter of sponsorship from the Conference of California Bar Associations. We have a letter from Judicial Council of California in support. We have a letter from the Los Angeles County Superior Court in support of it, the Civil Justice Association of California. And we've also had expressions of support from the American Arbitration Association and as well, of course, the Orange County Bar Association. And currently just one organization has expressed opposition, which is the Consumer Attorneys of California.
You can always twist the turns to cause a problem. Let me ask you this question. Does the proposed legislation only require both parties to meet and confer and try to settle the case? Or does it change existing code of civil procedure that would allow a judge to require parties to mediate?
Yeah, so this is more of the latter, but there's a lot of context that's important to understand around this. Number one, it only applies to counties which actually elect into this program. So this started out as a pilot program in Los Angeles in 1993, and any other counties that elected into it. And any county that elects into it can also immediately rescind and get right out of it. They can revoke that election. So it doesn't apply to everyone. It's just whichever county self select into it, number one. Number two, as I mentioned, it's only for cases up to 150,000 in threshold. Currently, small claims cases are excluded. They're not required to mediate. And because the small claims jurisdictional limit has increased to 35,000, so currently only cases between 35,000 and 50 would fall into this. And so it's really a timely adjustment to that. Another thing to keep in mind, this doesn't mean all cases within that amount automatically get referred to mediation. The judge must take into account party preferences. They have to discuss with the parties the amenability of the case to mediation. So this isn't something that they're going to automatically be referring, but they'll discuss with the parties if there are valid objections. The court is not going to require mediation. But if they deem that it's appropriate, at that time they will. And there are many statistics, Howard. I've had the privilege of just combing through research on mediation and actually mandatory mediation to really look at statistics on settlement and success rates, because one may make the argument that mandatory mediation may not be as effective as voluntary mediation. And I've seen a lot of very favorable statistics for this. So just let me give you some more context. There's so much, and I won't have time to go into it in 30 minutes, but take a look at federal courts in California, for example. All of the federal courts require some kind of ADR. And then the Central District of California, I'm actually a mediator on the panel. You either choose to have a settlement conference with a magistrate, or you can go to private mediation, or you can choose a panel mediator. And even in those cases where they're pretty much all going without any vetting, you're still achieving at least a 50% settlement rate on cases through the panel mediation. So that's one statistic, but there was actually an early mediation program done through the courts over 20 years, a little bit over 20 years ago. It resulted in I think it was 451-page report, very detailed analysis. It was actually an early mediation program. And the statistics there, just for example, in San Diego, it had a mandatory mediation program. Over 5,000 cases, I think it was 5,035 cases, were mediated through that early mediation program. And it had a settlement rate between 58 and 76%. And what's more is of the ones that didn't settle, so the majority of them settled, and it was mandatory mediation. But I will tell you one thing that was helpful in that situation is the court did take party preferences into account, as is required by Rule of Court 3.891. So same thing going on here, but 74% of those cases that didn't settle, so majority of them settled, the minority that didn't settle, the parties still said that the mediation was beneficial. So it's beneficial one way or another. There's other statistics from Sonoma. It was very similar. It had majority of the cases settling, but in that case, I think it was 90% of the ones that didn't settle say that it was beneficial. Of course, Howard, we know there are so many benefits from mediation that you don't get with trial. self-determination, creativity, cost savings, time savings, preserved relationships. There's a lot of reasons to do it. I mentioned earlier inflation. So $50,000 in 1993 is equivalent to 104,000 today. So this is just slightly above the inflationary adjustment. But now let's look at the context of our courts, the status of our courts. We have such a horrendous backlog, Howard. So this is a statistic that I heard from the dispute resolution section annual conference, spring conference just a couple weeks ago. California has 12% of the nation's population, but 60% of its litigation. I have to mention this and we'll go because it all fits together and we'll go back specifically to California statistics. But so I am a co-chair of the ABA dispute resolution section's early dispute resolution committee. I've had that role for the last 4 years. About 2.5 years ago, our committee decided that we want to propose a resolution for the ABA. And that was a resolution urging the increased informed and voluntary use of early dispute resolution, which includes methods such as negotiation, mediation, and ombuds. And we had a team work very hard on that, which included Mary Cullen of Minnesota. She's my co-chair at the time. Felicia Harris Haas is my current co-chair. And Meg Willoughby, who is the co-chair of the Ombuds Committee. We did a lot of work on this. Felicia and I went up to Kentucky in February and we presented, and it was unanimously adopted by the House of Delegates. 600 people adopted it. It was amazing. But what was really interesting about that trip and everything leading up to is that we were citing statistics from federal court about the backlog. And everyone's jaw was dropping about what a crazy backlog. But first of all, state courts are more stretched for resources than federal court. And California has the most horrible statistics out of every state that I've seen. I'm sure New York's is also horrible. But let's talk about California. In the last 3 years, civil case filings in each of the last 3 years, civil case filings were more than double civil case dispositions. And by the way, the filings have been increasing since 2013. So as a result of that, the last 3 years, the backlog has grown the civil backlog in California has grown by 885,000 cases. Nearly 1 million cases were added to the backlog. I'm not saying these were total cases and some of them were disposed. They were added. So we have a real problem here with timely adjudication.
I've got to add some. I remember a time. Have you ever heard of the fast track rules? It's become a misnomer, but I go back to college practicing where twice a year we would go into the calendar report, and that's when they would schedule the trials. And you'd find out, oh, I've got an hour and a half or 2 hours before the judge calls our matter. So that was when they used to have attorney lounges with the old beat up leather couches, and people would be smoking cigars in it. Okay. And I don't know if I've ever saw a woman in the attorney lounge at the time. But when they scheduled trials, it would be like 5 years away. It would be so then they developed these fast track rules where, if I recall correctly, judges had a quota where they had to get cases to trial within 12 months. And of course, now that's impossible. So I think that requirement has been thrown out, but that just shows you how we once were very slow in adjudicating civil matters. because the criminal matters always took priority. We determined that it was time to speed it up, which we did. And now, for all kinds of reasons, including a judicial economy, we can't get this stuff moving, which is one of the reasons why I started retiring from the practice of law and just mediating and arbitrating. I got just very frustrated over.
We all know the statistics that 98% of cases settle, but the problem is they're settling really late and they can settle earlier, and that will make a big difference. And so in California, Senator Umberg recently brought new legislation requiring initial disclosures at the early stages of a case, much like the federal counterpart. And I think that is going to be really helpful. And so now when we're talking about mediations, should be showing up prepared. They should show prepared anyways. But this idea that, oh, I don't know enough about the case yet, I think that gets diminished with this. There really isn't any excuse to get ahead of the information that you need to know to come prepared to a mediation.
Yeah, the kind of mediation I think that you're talking about is not an advisory mediation. It's more of a facilitative mediation very early on, because you're not going to have all of this. Everybody's going to sit down and go, are we going to be better off if we settle this case before we spend a couple of $100,000 in legal fees and delays? What are the practical necessities? And that's the kind of mediation and need to. I don't think the vast amount of attorneys really understand that. It's almost like, why don't you take some mediation courses and gain a different perspective and appreciation for the art of mediation?
This is a perfect time for me to put in a plug for two programs. They are free of charge. They are completely open to the public, ABA and non ABA members. The EDR committee, Early Dispute Resolution Committee of the Dispute Resolution section, is co hosting a series of two programs with the TIPS ADR committee. And so the first one is May 14th. It's on risk analysis. It's an outstanding program. We have a stellar lineup. And the second one is on June 4th on early mediation. And again, we have an amazing panel on that. People can send me a message on LinkedIn if they're having trouble finding these programs to register. But talking about the tools, there are a ton of tools in our EDR toolbox. So we're trying to remove any kind of hesitation for attorneys to start entering into negotiations earlier. And also back to SB 1141, just to make clear, it's not a mandatory early mediation. It may be something that comes along later in the case. Again, the judge has to confer with the parties. And if they say they're not ready, I don't think any judge was going to force that upon them. But when we think about our rights to timely adjudication, the whole purpose of this is to protect that fundamental right. Imagine you are a party in court and you actually absolutely do need your case to be tried. But you have all these other cases that don't really need to be there, and they're preventing you from getting a timely trial. That's not good. That's not okay. So I think we do need to remove some of that congestion, some of that bottleneck to actually preserve our fundamental right.
Great. All right. Anything else on that topic?
I'll just throw out also, I love statistics because I think that's what needs to drive our reasoning and decision making instead of small anecdotal scenarios. But I will also mention that so the Judicial Council puts out very thorough and detailed statistics. We are not meeting any of our case processing times, 12 months, 18 months, 2 years. We're meeting nothing. So yeah, we need something to jumpstart. And here's one more point is another thing actually I heard from the wonderful dispute resolution conference, this statistic. Judges were having something like 600 cases per judge. It's now up to about 1,200 cases out here, and which is actually causing more judges to retire. Okay, so it's like making this bad problem much worse. And then, of course, there's budgetary issues as well. And so this is really a can help save costs for litigants and for courts, which are really important. So many good reasons to go forward. But look, one way or another, if things get expensive, it's going to get passed on to the parties. Maybe filing fees will have to be increased. And one more point, Howard, and if you want, we can move topics, but there are actually a lot of free mediation programs, free and low cost mediation programs throughout the state. Sure, there are private mediators that charge a lot of money, and parties, if they have the money and they want to do that, are free to do that. But there's also many programs which are free. I was on the phone with, I've been researching this because if you propose something, you got to have the facts to back it up. But there's a Sacramento Mediation Center, for example. And I said, how much do you charge? They say, we have a $25 filing fee. And if you make, below 25,000 a year, then you pay $25 for the full mediation. And I said, what if you make $100,000? Then what do you pay? Then you pay $100 for the whole mediation. This is affordable. It's much more affordable than paying a lawyer or even just taking your time into account, missed work because your lawsuit is dragging on for way too.
Yeah, here in Las Vegas, for the last 2 years, I volunteered with the Clark County Neighborhood Justice Center. And most people don't even realize I get telephone calls. We need to mediate our case. And I said, you can't tell me too much about it without the other person, because I don't want to talk to one person versus the other. I can ask, what's the dispute? What's the nature of this landlord tenant matter, dog barking, contract, deposits, what? And I say, pull up the Clark County Neighborhood Justice Center, and they won't charge you, and they will give you 3 2-hour session mediation sessions, and it won't cost you a thing. Not only that, you still get me because I volunteer there. There's a lot that's available, and people don't have to be referred by the court in order to take advantage of this. And I've got to tell you, while my goal in mediation is not to get the parties to come to an agreement, I'm not a believer in cutting the baby at the and patting myself on the back if the party's settled. As a mediator, my goal is to get people to communicate because they're in the dispute because they're unable to communicate. So th- do it as early as you can. Uh,
100%. And it's okay
yeah,
if it doesn't settle. That's what we have a court for. Great. We have a court.
yeah,
We're just, this process should be efficient, right?
absolutely. Or you hire me as an arbitrator. So either one. We've got about 5 more minutes. Why don't you tell us what are your top 2 or 3 takeaways from the dispute resolution section annual conference this year in San Diego?
It was a lovely, lovely conference. I led one of the panels actually, so that was really fun. I led a panel on practice development, and this was something that was new to the conference. So I felt very privileged to do it. We had Lee J. Berman and Angela Reddick-Rott, Judge Ramona C. on the panel, and they gave some really wonderful tips for practice development. One of the things they shared is you really shouldn't be shy if you're trying to market yourself as a mediator because you got to go out there and meet people and network and shake hands and get to know people. But they had a really vibrant discussion. And then the panel after mine was amazing too. That's where I was quoting some of the statistics that were thrown out there. It was by the leaders of our big ADR providers like in AAA, Jams, ADR Services, Miles Mediation. That was a terrific panel. One of the things that was mentioned was a rising tide lifts all boats. That was said by Bridget McCormick, the CEO. And it really, to me, captures the feeling of our section, which is we are all so supportive of each other. When you think about people in our section, mediators, Our peacemakers. And we're also all volunteers. Volunteers are very giving people. So when you feel like you're going to the conference, you're walking in to a room full of friends. And to me, that part, the education was wonderful, but just the spirit of friendship that you feel when you're there in person is really special and really an irreplaceable feeling. And that's why I keep coming back, because the work is so meaningful and the people are really special. And Howard, I just feel so lucky to be in this community. And then the next day, there was a plenary that I really enjoyed by Professor Orly Lorable. She talked about tomorrow's technologies and AI and how we have to really be fair in making evaluations and criticizing it and comparing it to human decision making. Very much enjoyed that as well.
I feel so bad. Last year was the first one I had been to. Of course, it was here in Vegas, so it was easy for me. But I really enjoyed it so much, and I was very disappointed I was unable to make it this year. But even I did an interview with Sam Bold and David Larson last year before last year's conference, and everybody talked about, well, it was the first conference that had been in person for a couple of years because of COVID. That was key point that everybody thought was getting to meet and remake and reacquaint themselves with old friends. And it really is it's a great section. And I have met so many people. And I might add, I'm pretty sure I'll be able to make it to Atlanta to the arbitration conference, which will be the third one I'll go to. And I love that.
I'll be there too. So I get
Well,
to see you in person.
yeah. All right. Great. I'm looking forward to it. Yeah. I love that conference. I was the one in Chicago and the one in New York. And every year I was less and less able to walk. Uh, but hopefully I'll be able to walk without a cane. I'm not really sure, but we'll see. In any event, Ellie, thank you very much. I appreciate you taking the time, and it was really great meeting you and talking with you. And all that you talked about was great. This is, and I hope that this will be within the next couple of days, and I'll send you a link. Please remember, now, how do people get a hold of you?
So you can find me on LinkedIn. You can send me a message there. I check it. I'm pretty accessible. Yeah, always happy to share, when I know, help people in any way I can. And if anyone listening is interested in early dispute resolution, please join our committee.
And I need to do that because I'll become, it's look nice. If you understood that, you would really give it a good shot right in the beginning. And if you do it through mediation, honestly, it's not like you're going, okay, I don't want to show weakness. This kind of makes sense, which is why I'm kind of in favor of the courts requiring it. I think the base should be require mediation unless there's a reason not to do it. So if someone's over the age of 70 and they need to get this thing resolved, take that into consideration.
It's interesting how we could go on for a lot longer. And so I probably need to stop talking, but I was made aware, we had a wonderful presenter, Terry Breer. She does fabulous work in EDR and family law. And she told me about the new requirement in Israel. It's a couple of years old. They actually mandatory EDR before you file, and they've dramatically reduced their backlogs and have had a lot of success and benefits with their program. So
I think the important thing is, well, I'm going to close, it's educating the public. People just don't understand, including the attorney. They, for the most part, they don't understand what mediation, the benefits, and they don't understand collaborative law. and they don't understand arbitration and all of the benefits of ADR. And if they fully understood it, I think that more people would take advantage.
I agree. We'll continue to try to share thoughts and educational opportunities. Thank you for your good work, Howard. You're one of those beacons of light that are making the world a better place.
Is that light reflecting off the top of my head?